A prenuptial agreement is a contract that governs how a married couple's assets will be divided in the event that they someday get divorced. Prenuptial agreements are commonly known as prenups. In this video, we'll address prenuptial agreements in Hawaii, including how the agreements work, Hawaii's specific signing requirements, and situations when an otherwise valid prenuptial agreement might not be enforceable. Whether to get a prenuptial agreement is a personal decision. Keep in mind that even bringing it up with your partner could have big implications for the relationship. If you are considering pursuing one, it's probably always best to speak with a financial advisor before you begin the process of creating an agreement. Make sure to watch to the end of this video so you can access an official lawyer-approved template from eForms. The first question you might have is, what is needed for a valid prenuptial agreement in Hawaii? Hawaii allows prenups and requires that both parties sign the agreement in order for it to be effective. While most contracts require some kind of exchange of value, usually called consideration, to be effective, there is no consideration requirement for prenuptial agreements. Both parties have to sign the agreement, but prenups become effective when the marriage begins, not when the contract is signed. Even if both parties do sign the agreement, there are some situations in which the prenup might later be thrown out. For example, if one partner does not disclose all financial assets or liabilities, then the agreement may later be unenforceable. The agreement will also not be enforced if there is sufficient evidence that one party did not sign the agreement voluntarily. While whether it's voluntary may ultimately be a question to be decided by a judge in a divorce proceeding, one way to help ensure that an agreement is seen as voluntary is to make sure that both spouses are able to consult with separate attorneys before signing. What should prenuptial agreements contain? Like most contracts, prenuptial agreements give the people who are drafting them flexibility. They can include various assets that either partner has accumulated and address difficult to divide assets like real property. It's also important to think about what the agreements cannot contain. Prenuptial agreements cannot be unconscionable, a legal term that essentially means grossly unfair to one side. Whether a term in a prenup is unconscionable will ultimately be up to the judge overseeing the case. One term that is likely to be deemed unconscionable is a provision removing the obligation of one party to provide spousal support if it results in one partner becoming eligible to receive public assistance from the state of Hawaii. Can prenuptial agreements later be changed? Yes, like most contracts, prenuptial agreements can later be modified or revoked after they're signed, including after the couple has gotten married. Doing so requires a written document subject to the same validity requirements as the original prenuptial agreement. Like the original document, no consideration is required to modify or revoke. For a sample prenuptial agreement that is enforceable in Hawaii, click the link here. And don't forget to subscribe to keep up with other videos addressing related legal issues.